seated. It's 10:38 on the courtroom clock. Wednesday, May 2, 2018. Record 11 all-12 jurors and 5 alternates as returned to the courtroom. Mr. Grate is present with counsel as our counsel for the state of Ohio. Ladies and gentlemen of the jury, in your absence this morning, a number of the charges contained in the indictment were resolved, meaning they won't be submitted to you for determination. However, there remain matters that you still must decide, a number of charges and specifications that you will consider and make a determination of. But because of this partial resolution this morning, that may have an impact on the remaining evidence that's presented in this case. And I want to admonish you now, as well as remember to do that in the future, that anything that's previously been resolved in this case is not to be considered by you in any manner for any reason whatsoever when the remaining issues are submitted to you for determination. You're not to consider any of the evidence that was presented in those matters that are now resolved that might be irrelevant to the charges that are submitted to you later for determination. When you consider those other charges, you are to consider only the relevant evidence to each charge and decide each charge and specification separately, apart from any other charge or offense you may decide or render a decision on. Anything else we need to address with counsel before we proceed with the state's next witness? Mr. Tennell?
No, Your Honor. Thank you.
Mr. Whitney?
No, Judge.
Okay. Thank you. Then the state may call its next witness.
Feldenkris. And you solemnly swear or affirm the testimony about this matter to be the truth. Thank you.
Please state your full name and spell your last name for the record.
Emily Feldenkris, Feldenkris.
Ms. Feldenkris, how are you employed?
I am a forensic scientist with the Ohio Bureau of Criminal Investigation.
What does a forensic scientist at BCI do?
A forensic scientist is a scientist that uses science in the pursuit of criminal matters. At BCI, there are several different types of forensic scientists. Myself, I work in the forensic biology and DNA section.
How long have you been a forensic scientist at BCI?
Since 2011.
And did you receive any specialized education or training to qualify you for your employment?
Yes, I have a Bachelor's of Science in Molecular Genetics from The Ohio State University. Upon beginning my employment at BCI, I underwent a 3-month in-house training program in the area of forensic biology, as well as an 8-month in-house training program in the area of forensic DNA analysis and interpretation. I also have undergone many different continuing education classes, as well as lectures and conferences.
So what specifically, Ms. Feldenkris, do you do at BCI?
I'm a forensic scientist in the DNA section, and what a forensic scientist in the DNA section does is they can examine items for the presence of body fluids or take samples, but primarily what I do is I analyze data that's generated from those samples, make conclusions about my findings, type reports to those findings, and testify in court as needed.
What kind of data do you analyze?
I analyze DNA profile data that is generated from items of evidence, as well as individuals' reference standards.
So generally speaking, Ms. Feldenkris, can you take us through the process whereby a profile is made so that you can compare that?
Yes. The DNA analysis is generally a 4-step process. After samples have been taken by a forensic biologist, they will undergo extraction, where the DNA is separated from the rest of the cellular material. Second, DNA is quantified, or we find out how much DNA we have in a particular sample. After that, the next step is amplification, which is similar to a chemical Xeroxing process that allows me to make millions of copies of the target regions on the DNA that I'm examining. And then lastly, I will examine the results of that test where a DNA profile has been generated and compare a DNA profile from an item of evidence to an individual's reference standard to either include or exclude that individual as being a potential contributor to the DNA.
You mentioned in the, I think it was the second part, you're looking for quantity of material, is that correct?
Yes, that's correct.
So is it fair to say that in a sample, you can have different amounts of genetic material present?
Yes.
In some instances, do you have enough where there can be a profile generated and you can then compare that to another profile to say if those, to what degree they are similar?
Yes. Ideally, we would have enough DNA in every sample that we test, but occasionally there is not enough DNA left behind, or there's no DNA left behind, and I can't make any determinations about those types of samples.
You mentioned the target area. Can you tell us about that? Asked another way, when you're looking at a profile, are you looking at the entire length of DNA and all the material in there, or just a particular section of it?
Just particular sections of the DNA. Our DNA is over 99% identical between individuals, so for forensic analysis, I'm only interested in looking at those portions of the DNA that are unique to each individual. There are the tests that we use examine, in this particular case, 15 different locations on the DNA that are unique between individuals, and a sex-determining marker to see if that DNA came from a male or from a female.
So when you look at those different regions and you compare them, do you get, and you're trying to determine the similarities between these two samples, hypothetically, do you then make a determination, yes, this is definitely the same source of DNA for both of these? Or does it work another way?
Can you rephrase the question, please?
When you're looking at two samples to determine whether or not you've got these 15 markers, whether or not they are the same or similar on each one of your samples, when you're reaching a conclusion regarding your analysis, you say, yeah, that is the same DNA in both of these samples, or is there another way that you look at these things involving statistics?
Yes. So when I test the items of evidence with those 15 markers as well as the sex-determining marker, I'll run that same set of tests on an individual's reference standard. And then that will allow me to make a direct comparison between the two profiles. When I find that the two profiles are the same, or they match, or they're consistent, then I will generate a statistic to determine how common or rare that evidence profile is, to see what the potential chances of a coincidental match to that profile are.
Okay. And so the bigger the number, the rarer that chance of another copy of that. Is that fair to say? So if it's 1 in 200,000, it's more likely that there could be another instance of that particular profile, whereas 1 in 1,000,000,000,000 would be much rarer.
That's correct.
Okay. Now, DNA in general, we heard some testimony yesterday from Ms. Hammett, who explained that we've all got DNA, and if we touch things, sometimes DNA is left behind. Is that fair to say?
Yes.
Is DNA left behind every time somebody touches something?
Not necessarily.
Okay. So if you were going to do an analysis of this pen, you can't say where you're sitting right now if my DNA is on this pen, even though you see me holding it. Is that correct?
That's correct. If I were to test the pen after you set it down, I may or may not detect your DNA. It depends on how many cells you leave behind, if that pen is then cleaned, if the pen is left outside in inclement weather. And there are factors that can impact how much DNA is detected on a particular sample.
Okay. Ms. Feldenkris, when you are performing a comparison of two samples, you walked us through the process. What are you looking at when you're making these comparisons, when you're looking at these 15 markers?
I'm looking at locations on the DNA where there are something called short tandem repeats, or locations where you have sections of your DNA code that repeat one after another. And what I'm doing on each half of your DNA, so you get half of your DNA from your mother and half from your father, you have 2 copies. At each of those locations, I'm testing how many different repeats you have.
Okay. When you are doing an analysis, you've got a sample and you've got a standard and you're comparing these things together. Do you generate a report?
Yes, I do.
And do you do that in every case?
Yes, I do.
Were you asked to do a report in this case and do an analysis?
Yes, I was.
Shawn Defense Counsel states it to 377, 378, and 379.
Thank you.
Ms. Feldenkris, for purposes of the record, 377. Do you recognize what that document is?
Yes, I do.
What is that?
This appears to be a fair and accurate copy of my CV.
Okay. And is that kept in the ordinary course of business at BCI?
Yes, it is.
In fact, typically it's attached to each report you do, so anyone who receives an Emily Feldenkris report can see this is Ms. Feldenkris's training and credentials.
That's correct.
Okay. State's Exhibit 378, I'm going to hand you and ask you if you recognize it. There are a couple of marks on here that would not be original to your document. We'll talk about those and what pages those are on. But 378 generally, you recognize what that is.
Yes, I do. This appears to be a copy with modifications of the report that I generated in this case.
And the modifications, there are some redactions. Does that appear to be the case?
Yes.
On the first page, there's a portion redacted. Is that correct?
Yes.
The third page, there's a portion redacted.
Yes.
And then on the 9th and 10th pages, there are portions redacted. Is that correct?
Yes.
Aside from those redactions, the remaining material, does that appear to be a true and accurate copy of those portions of your report?
Yes, it does.
And just like with your CV, is this report for BCI lab number 16-310871 kept in the ordinary course of business at BCI?
Yes, it is.
So in this particular case, you were asked to do an analysis on some materials. Is that correct?
Yes.
I'm going to hand you State's Exhibit 257 and ask you if you recognize that relative to your analysis in this case.
Yes, I do.
What is that?
This is BCI item number 1, or the rape kit from Lorinda Svihalik that was submitted in this case.
And how do you know that?
Based on the BCI barcode that is given to each item as it is submitted to our laboratory, as well as the BCI case number and item number.
So that wouldn't have been that box which you received, correct? You got swabs and samples that Ms. Hammett had collected.
Yes, Ms. Hammett collected samples from this item and sent those forward for my analysis.
But you can recognize that because of the way that BCI keeps their records and that sticker on there. Is that right?
Yes.
All right. So with item 1, there were 2 parts of that you did an analysis on. Is that correct?
Yes.
There were vaginal swabs and then a DNA standard. Can you tell us what did you do with those?
Yes, DNA analysis was performed on the DNA standard from Lorinda Svihalik in order to generate her DNA profile for comparison. I also performed DNA analysis on the vaginal swabs, and the DNA profile from that resulted in a mixture consistent with contributions from Lorinda Svihalik and Shawn Grate.
And you would expect from a vaginal swab for the person from whom the swab was taken for their DNA to be present. Is that correct?
Yes.
Now, to compare the swab from State's Exhibit 257 to a DNA profile for Shawn Grate, I'm going to hand you 262, State's Exhibit 262. Did you have, or were you provided a profile for Mr. Grate that you could use to make that comparison?
Yes, I was.
And is that item 262?
Yes, it was. This is the DNA standard from Shawn Grate.
And that's item number 2 on your report, is that right?
Yes.
Okay. So you had that, or a swab from that Ms. Hammond did, compared that to the swab samples that you've already described to determine that Shawn Grate's DNA was in that vaginal sample.
Yes, that his DNA profile was consistent with that sample.
And let's talk about what that means, because we had mentioned earlier statistics, and then you come up with a statistic for that. So what was the statistic for that?
The DNA profile in the sperm fraction that was not attributed to Lorinda Svilik was rarer than 1 in 1 trillion, meaning I would have to test over 1 trillion individuals in order to expect to find that particular DNA profile.
Okay. Item number 4, what was that?
Item number 4 was a sexual device.
And what analysis did you perform on item number 4?
I tested 5 samples that were taken from that sexual device. A swab of condom, a swab of toilet paper, a swab of another condom, a swab of paper, and a swab of a candle and ball.
Okay, let me interrupt there. Could counsel please approach?
Ms. Feldenkris, we were talking about item 4, and there were a few swabs from that item that you compared to the DNA standards that you had. What was and you told us what those were from. 4.1 was the swab from the condom that was on that device. What were the results of your analysis for that item?
That DNA profile from the swab of the condom, BCI item 4.1, was a mixture consistent with contributions from Shawn Grate, as well as additional data that I could not make any comparisons to.
What does that mean?
On this particular sample, his DNA profile was the major DNA profile, and then I detected additional DNA that was there, but it was too low to make any comparisons to. There was not enough of it.
So this is like we were talking before, when you're looking at the quantity of material that's there, if you don't have enough, then you don't have enough data to make a comparison. Is that fair?
That's correct. I can't include or exclude anybody from that additional data.
And really all you know is that there is some other DNA present there, some other source of DNA present there. Is that correct?
Yes.
Now, you were able to exclude as major contributors 3 people on that. Is that correct?
Yes.
And who were they?
Lorinda Svilik, Stacy Hicks, and Elizabeth Griffith.
What does it mean when someone's excluded as a major contributor?
That means that they were not the individual that contributed the most DNA to that particular sample.
Okay, so the major contributor or the largest amount of profile that you could see, that was that number you said for Shawn Grate, 1 in 1 trillion, is that right?
Yeah, that profile was consistent with Shawn Grate, and I would estimate the frequency of that profile to be rarer than 1 in 1 trillion unrelated individuals.
And so we know for sure that wasn't the 3 women whose names that you said, correct?
Correct.
All right. But we don't know who was the source of that additional data not sufficient for comparison. Is that correct?
Correct.
Item 5, what was that?
Item 5 was a sexual device.
And what analysis did you perform on item 5?
On item 5, I tested 8 samples, a swab of a condom, a swab of a sock, actually 5 swabs of sock, a swab of a ball and a sock, and a swab of balls.
And 5.1 was the swab of the condom, is that correct?
Yes.
What was the result from that analysis?
Item 5.1, the DNA profile was consistent with Shawn Grate.
And was that same number rarer than 1 in 1 trillion?
Yes.
Is that correct? Okay. And for Lori Svillick, Stacy Hicks, and Elizabeth Griffith, they were excluded from that. Is that correct?
Yes.
Now, what's the difference between excluded like in that versus excluded as a major contributor from the previous item we talked about?
For this particular sample, their DNA profile was not consistent with any of the DNA profile generated from that sample. The other sample did have additional DNA that I couldn't make comparisons to, so essentially they or anybody else would be inconclusive to that additional data.
Now, Ms. Feldenkris, there are, from these swabs of socks, for example, 5.3, did you find an unknown female sufficient for comparison on 5.3?
Yes, I did.
Now, if these items were previously owned or possessed by someone else, these items of clothing, and if they had been worn, would it be surprising to you that other sources of DNA might be present on those clothing items?
No, that would not be surprising.
Okay. What was item 6?
Item 6 was also a sexual device.
It shows you the mark for identification purposes as State's Exhibit 122. Do you know what this is?
State's Exhibit 122 is BCI item number 6, the sexual device.
Okay. This would have been the item that Ms. Hammond did the swabs for that you then provided some analysis on. Is that correct?
Yes.
What analysis did you do on item number 6?
On item number 6, I tested 7 samples taken from that item. A swab of the handle end, a swab of a condom, a swab of another condom, a swab of a sock, a swab of duct tape, a swab of a towel, and a swab of the end of the stick that was underneath those layers, or the swab of the non-handled end.
And then those were broken down into, in the report here, sub-items, so 6.1, 6.2, et cetera?
Yes, all the way to 6.7.
What was 6.1?
Item 6.1 was a swab of the handle end.
And what was the result of your analysis of that?
That DNA profile was a mixture. The major DNA profile was consistent with Shawn Grate, and there was additional data that was not sufficient for comparison.
And for Lori Svillick, Stacy Hicks, and Elizabeth Griffith, did you have any analysis or findings concerning their DNA profiles?
They were all excluded as the major contributor from that sample.
Okay, but not enough data in that other source, is that right?
That's correct.
6.2, what was that and what did you do with it?
A 6.2 was a swab of a condom. That DNA profile was a mixture. A major DNA profile was consistent with Shawn Grate, and there was also additional data that was not sufficient for comparison.
Were Lori Svillick, Stacy Hicks, and Elizabeth Griffith excluded as the major contributors?
Yes.
Again, okay. But again, not enough information or material to be able to make a full comparison on that other source of DNA.
Yes.
6.3, what was that and what did you do with it?
Item 6.3 was a swab of a condom. That DNA profile was a mixture. The major, Shawn Grate was consistent as being the major contributor in that sample, and there was additional data that was not sufficient for comparison.
Same thing we had before, is that right?
Yes.
.4, what was that?
Item 6.4 was a swab of a sock.
What did you do with that?
I ran the same DNA analysis on that, and that DNA profile was a mixture consistent with contributions from Shawn Grate and an unknown individual.
Okay, and to be fair, same thing we said before, if someone had worn that sock before, you wouldn't be surprised for their DNA to be on it, is that right?
That's correct.
Okay. 6.5, what was that?
Item 6.5 was a swab of duct tape, and the DNA profile from that was a mixture consistent with contributions from Shawn Grate and that same unknown individual.
Item 6.6.
6.6 was a swab of a towel. The DNA profile from that item was a mixture. Shawn Grate was consistent as being the major contributor, and there was additional data that was not sufficient for comparison.
Backing up just for a moment, 6.4, the swab of the sock, and 6.5, swab of duct tape. It was the same profile, an unknown profile for that?
Yes, that was the same unknown profile on both items.
Okay. 6.7, what was that and what did you do?
Item 6.7 was the swab of the non-handled end, underneath all of the layers. That DNA profile was a mixture. The major DNA profile was consistent with Shawn Grate, and there was also additional data that was not sufficient for comparison purposes.
Item 7, what was that?
Item 7 was also a sexual device.
And what did you do with item 7?
I tested 5 samples from that item.
Were each one of those swabs consistent with Shawn Grate?
There was additional data that was detected, and on the swab of the non-handled end, that sample was not suitable for comparison purposes.
Okay. The rest of it, though, was consistent with Shawn Grate, is that right?
Yes.
And the 3 women that we've been talking about, Lori Svilik, Stacy Hicks, and Elizabeth Griffith, were excluded either as a major contributor or excluded entirely from those items.
That's correct.
Is that correct?
From anywhere I had interpretable data, they were excluded.
Okay. But for 7.2, the swab of the sock, there was a DNA profile, not enough information for a comparison. Is that right?
The 7.2 was a mixture. The major DNA profile was consistent with Shawn Grate, and there was additional data that was not sufficient for comparison.
Was that the same as with 7.3 swab of sock and duct tape and 7.4 swab of the handle end?
Yes, it is.
Okay. What was item 8?
Item 8 was also a sexual device.
And how many swabs from that did you test?
There were eight swabs tested from that item.
8.1, swab of material on condom. What was the result of that analysis?
That DNA profile was consistent with Shawn Grate.
And were any of the profiles that you examined in this case excluded as contributors to that item?
Yes. Lorinda Svilik, Stacy Hicks, and Elizabeth Griffith were excluded as being contributors to that sample.
Okay, and was that the same with 8.2 swab of condom and sock and 8.3 swab of condom?
Yes.
8.4 swab of condom, what was the result of that?
The DNA profile from that sample was a mixture. The major DNA profile was consistent with Shawn Grate, and there was additional data that was not sufficient for comparison purposes.
And was that the same for 8.5 swab of sock?
Yes, it was. I obtained the same result.
And 8.6 swab of sock?
Yes, same result.
For 8.7, the swab of the handle end, and 8.8 swab of the non-handle end, was there enough data there to make a comparison?
No, I had enough information present to know that I had a mixture or DNA from multiple contributors, and that there was male DNA detected, but I couldn't make any comparisons to either of those samples.
What was item 9?
Item 9 was a sexual device.
What analysis did you perform on that item?
I tested 6 swabs from that item.
Okay, 9.1 swab of condom, what was the result of that analysis?
The DNA profile from item 9.1 was consistent with Shawn Grate.
And were any of the profiles that you looked at excluded?
Yes, the Lorinda Svilik, Stacy Hicks, and Elizabeth Griffith were all excluded. as being the source of that DNA.
And was that the same finding for 9.2 swab of condom, 9.3 swab of condom, and 9.4 swab of pantyhose?
Yes, it was.
.5 and 9.6 were also consistent with Shawn Grate's DNA, is that correct?
Yes, he was included on both samples. For 9.5, that sample was a mixture. The major profile was consistent with Shawn Grate with additional data not suitable for comparison. And 9.6, the swab of the candle, was the DNA profile was consistent with Shawn Grate.
Item 10, what was that?
Item 10 was a sexual device.
And what analysis did you perform on that?
I tested 5 swabs from that item.
Item 10.1, swab of condom, what was the result of your analysis of that swab?
The DNA profile from that sample was consistent with Shawn Grate.
And were any of the profiles that you looked at excluded as contributors, potential contributors for DNA?
Yes, Lorinda Spillick, Stacy Hicks, and Elizabeth Griffith were all excluded as the source of the DNA on that sample.
And was that the same result for 10.2, swab of condom?
Yes, it was.
For 10.3, the swab of interior neck and arm pit areas of a shirt, did you have enough data to make a comparison?
No, I did not. That DNA profile was not sufficient for comparison.
10.4, swab of exterior of shirt. 10.5, swab of candle and aluminum foil. What were the results for those two?
Both of those samples, the DNA profile was consistent with Shawn Grate.
Item 12.4.1 and 12.5.1, what were those?
12.4.1 was the swab from under the right fingernails from Stacy Hicks, and that data, which I could tell included male, was not suitable for comparison. And so there's too little amount of DNA there to make any inclusions or exclusions to that data. 12.5.1 was a swab under the left fingernails from Stacy Hicks, and that gave the same result, that there was an indication of male DNA. However, that sample was not sufficient for comparison.
Okay, so the results of your analysis that you have recorded in the report that we marked as State's Exhibit 378, were those based on your education, training, and experience and within a reasonable degree of scientific certainty?
Yes, they're based on my education, training, and experience.
Okay. Angela Smart, for identification purposes, as State's Exhibit 379. Do you recognize what that is?
Yes, I do.
What is that?
State's Exhibit 379 appears to be a fair and accurate copy of a report that I generated at BCI.
And is that a fair and accurate copy of that report?
Yes, it is.
For BCI laboratory number 16-37213?
Yes.
Is that kept in the ordinary course of business at BCI?
Yes, it is.
All right. And were you asked to do an analysis on items for that report and compare them to the DNA standard of Shawn Grate that we've already talked about?
Yes, I was.
Okay. So I handed 2 exhibits here. 386, which BCI item is that?
State's Exhibit 386 is BCI item number 2, clothing that was found at the scene.
Okay. 233 is what BCI item number from that particular report?
State's Exhibit 233 is BCI item number 3.
Thank you. And did you perform an analysis on samples taken from those items consistent with what you've already testified to, the process by which you do these kinds of things?
Yes, I did.
Okay. And what was the result of that?
A swab was taken of the cutoff pants, BCI item 2.1. That DNA profile was a mixture. I could tell that mixture included male DNA, but it was not sufficient for inclusion, meaning I could potentially exclude somebody from that sample, but I could never include them as being a potential contributor. For that sample, Shawn Grate was inconclusive. I also tested a swab of the neck of the t-shirt that was found in item number 3. That swab of the neck of the t-shirt was consistent with Shawn Grate. And the expected frequency of that evidence profile was also rarer than 1 in 1 trillion unrelated individuals. I also tested a swab of the interior of sock number 1, and that was BCI item number 3.2. That DNA profile was consistent with Shawn Grate. And I tested a swab of the exterior of sock 2. It appeared to be found inside out. That was a BCI item 3.3. That DNA profile was also consistent with Shawn Grate. Both of those evidence profiles, the expected frequency of those profiles were rarer than 1 in 1 trillion unrelated individuals.
And was that 3.3?
Yes, it
You
was.
just said, okay. Your conclusions there, are those based on your education, training, and experience and within a reasonable degree of scientific certainty?
Yes, they're based on my education, training, and experience.
Now, going back for just a moment to 378, every item that was tested in there, did that contain a DNA profile consistent with Shawn Grate?
Under item 2.1, I was not able to make any inclusions on that sample.
I'm sorry, I'm back on 378.
Oh.
First one we talked about. Sorry about that. So 378, from the items that were collected, so obviously we have standards from the victims of the case, but from the items that were collected and you're comparing profiles to determine if someone's DNA is present, were all the items there consistent with the DNA, at least one DNA profile found there consistent with Shawn Grate?
There were several samples that I was not able to make comparisons to. However, for the evidence samples, each of those main items, item 4, 5, 6, 7, 8, 9, and 10, all of them did contain a DNA profile that was consistent with Shawn Grate.
Okay, so for the ones where there was enough information to do a comparison, is that what you mean?
Yes.
All right. And for some of them, there was additional DNA present, but not enough for a comparison. Is that correct?
That's correct.
Okay.
Excuse me, can I clarify? The fingernail scrapings were not suitable for comparison, and those did not contain his DNA profile. That I could tell.
Okay, thank you. Thank you.
Cross-examine, Mr. Whitney.
Nothing, Judge, thank you.
Okay. Thank you, ma'am. You're excused.
Thank you.
Sir, do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, so help you God?
Yes. Thank you, Your Honor. Good morning, sir.
Morning.
Can you tell us your name
Joel David Eisenhower.
and spell your last name for the record?
Icenhour.
And how are you employed?
I got 2 part-time jobs. I'm employed as a part-time officer with the City of Ashland Division of Police and also as a bailiff for this courtroom.
Okay. And you have not been in the courtroom, however, for the course of this trial, correct?
That is correct.
You're a part-time officer with the Ashland Police Department. How long have you been a part-time police officer?
Since I retired from the Ashland City Police Department in May of 2015, about 3 months after that, I started a part-time position.
And prior to being part-time during your full-time, life, how long were you an officer with the Ashland Police Department?
Total, I've been an officer with a police agency for approximately 30 years. Ashland, just about 28 years.
Okay. Where were you before Ashland?
Ohio State University Police Department in Columbus, Ohio.
And what were your duties at the time of your retirement at the Ashland Police Department?
I was a lieutenant in charge of the Detective Bureau.
And how long had you been the lieutenant in charge of the detective bureau?
5 years.
Excuse me. And what are your duties currently as a part-time officer?
You know, anything that's needed, but typically, most of my duties have been cell phone and a device forensics examiner.
Okay, and why are you the go-to guy on the cell phones?
I did it before I retired, and I just kind of picked up where I left off.
Okay. Have you received any sort of specialized training in the analysis of cell phones?
Yes, I have. In 2010, I attended a course called Public Agency Training Council in Indianapolis, and attended a cell phone instructor course.
And what does that entail?
Basically, it's a forensics course, teach you how to forensically examine cell phones and such other devices, such as GPS devices, USB devices, and also to analyze cell phone data records.
I'll show defense counsel State's Exhibit 380. I'll show you what we mark for purposes of identification. There's 3 pages called State's Exhibit 380. You recognize those documents?
Yes, these are the documents I provided to the prosecution in reference to my training with the Public Agency Training Council.
Okay. Are those the certificates that you receive after successfully completing the training that you just told us about?
Yes.
Now, you said currently you're sort of the go-to guy on the cell phones. What's your experience in analyzing cell phones?
Well, at this point, I've analyzed approximately 1,500 to 2,000 different devices since 2010. So I've done a lot of devices, and I tend to, maybe accelerate in that area as far as investigative work.
And do you utilize any particular software or devices or technology to aid in your analysis of the cell phone?
Yes, currently I'm using 2 different software companies. One's called Sustine, and the other one is called Cellbrite, a forensic system.
And did you utilize one or both on evidence collected in this particular case?
I only use Cellbrite for this case.
And how does Cellbrite work?
Cellbrite is basically a program that's connected to the computer. It extracts the data files from the cell phone or device that you have running on it. It extracts it, and then it also parses the data. Basically, it organizes the data and puts it in a readable format where reports can be generated from it.
When you analyze the data on a cell phone, does it alter the contents of the cell phone?
I mean, yes, there's always a chance it will alter the chance of the cell phone. In fact, during our instructor's course, they said there will be some changes in the phone. Just by simply turning on the phone will actually alter the data from the previous state. It alters it in the fact of when the phone was activated and so forth. So there is a slight adjustment in the data in the phone.
So there could be data within the phone regarding to the or relating to the operation of the phone?
Yes.
Would it affect things like pictures or video?
No.
How about call records?
No.
Okay. I suppose there's always a chance you could delete everything on the phone while you're...
That's correct.
That could happen.
That could happen.
Okay. But in essence, the data from the cell phone is extracted, is that correct?
Yes.
So it's not removed, ideally, it's just extracted into another format, is that
Yeah, to make it simple, it's copied, yes.
Okay. So it's a little more complex than just flipping open a phone and scrolling through it?
That's correct.
Okay. Are you able to recover deleted data?
It depends on the phone make and model. It depends on, the firmware that the phone has and so forth. There's different variables, but in many cases I can extract deleted data and reconstruct it.
And in this particular case, how many phones did you analyze?
4.
Okay.
Well, you can almost say 5 because I also analyzed one of the officer's phone to extract a picture of evidence that he took, but that was just specifically for a picture.
Okay, so 5 overall. Of those 5, how many are alleged to have belonged to Shawn Grate, the defendant?
2 of them.
Okay. I'm going to show you what we marked as State's Exhibit 120. Tell us what State's Exhibit 120 is.
Looks like Ashland Police Department's evidence sheet logs.
Okay, and does that particular evidence sheet log indicate your handling of any evidence in this case?
Yes. Yes, it does.
All right, we'll start with State's Exhibit 140. Show you State's Exhibit 140, if you'd examine that item.
Okay.
Do you recognize that item?
Yeah, that's an acquittal smartphone, or not a smartphone, but they consider them dumb phones, but just a basic phone.
Okay. And his head, I guess as opposed to a smartphone.
As opposed to smartphone, yes.
Is State's Exhibit 140 one of the items of evidence you handled that is documented within Exhibit 120 of the evidence?
I have to go additional pages here. Yes.
Okay. Now, we've had prior testimony from Detective Evans that he was also engaged in the analysis of phones
Yes.
with you at the time. Okay. Do you, sometimes when you analyze a cellular telephone, do you generate what's known as an extraction report?
Yes, I do.
The defense counsel states it's a 3-1. And you states Exhibit 381 and ask, can you tell us what that is?
Well, it has my name on it, so it is a report I generated using the Cellbrite extraction report, and that would be the data I extracted from this acquittal cell phone.
Okay, and what sort of data were you able to extract from State's Exhibit 140?
I was able to extract the contact information, contacts that were programmed into the phone, as well as incoming and outgoing and missed cell phone calls, picture files. I believe I got audio files out of this, but I don't think there was any, but it had the capability of doing that if I'm not mistaken. And it had the capability of pulling out text messages too. With this extraction, I was able to extract 3 different ways. There's 3 different extractions out of the same phone. The first one is a logical extraction, which is just a basic extraction. And when you open up your phone, what you see is basically the logical extraction. The file system is a little bit more in-depth of an extraction. Sometimes through a file system extraction, you can pull out deleted data. Then the final phase is a physical extraction. Basically, it takes the whole volume or the capacity of the phone and extracts that. Then the data will be parsed through the physical analyzer, and that's where you probably get the most deleted data and unrecoverable data.
And with respect to your actual analysis of the phone, how far back could you determine calls were recorded on that telephone in time?
According to this report, it goes back to 1/1 of 01.
Okay, but actual usable,
9/6, I'm sorry, 9/6 of 16.
9/6 and 16?
Yeah.
Okay. There's some data that seemed to have recorded at like 1101
Right.
for whatever reason.
Sometimes just manufacturer and data interpreted.
Okay, but the actual, looks like ingoing, outgoing call record, there's nothing prior to September 6th of 2016?
Correct.
Okay. I'm going to draw your attention to page 4 of Exhibit 381. Now, when we're looking at the data on page 4, how is it organized time-wise? Is the earlier at the top or the later?
The later at the top.
Okay. So the last activity using the phone is at the top of that page and older stuff's at the bottom.
Correct.
All right. I'm going to draw your attention to line 12. Is there a call recorded at that line?
Yes, a missed call, line 12, the name program, and that's a name that's programmed from the contact list from the same phone, would be Tamara, I think.
Okay. Would you spell that, please, for the record?
Tamara.
All right. And is there a date and time associated with that call?
Yes.
Did it appear to you, in looking at the phone and your overall investigation and analysis of that phone, that the time and date appeared to be accurate?
Yes.
Okay. So what time and date was there a missed call recorded from a Tamara?
September 11th, 2016 at 3:36 p.m.
And that would have been an incoming or outgoing call?
It says a miss, so that would be an incoming missed call.
Okay, so someone in the contacts named Tamara called at that time
Yes.
is what we can conclude from that.
Yes.
And I think you said 3:36 on September 11th.
11th, yes.
Now, I'll draw your attention to the next set of lines, 8, 9, and 10. Are there call activity recorded at those lines?
Yes, there is.
And what activity is recorded?
These are outgoing calls to a Braden, all the same person.
Okay. 3 outgoing calls to a Brandon?
Or Brandon, I'm sorry. Yeah, Brandon.
Oh, I'm sorry.
Yeah, it is. I said Braden, it's Brandon.
Okay. And again, Brandon would be put on there because that's somebody in the contacts?
Yes.
All right. And what time and date did those take place?
They were all on September 12th, 2016. It started at 8:07 p.m., then it goes to 8:26 p.m., and again, 8:28 p.m.
And again, that's on September 12th
That's correct.
of 2016.
Yes.
And those are outgoing calls?
Yes.
So someone dialed those numbers associated with Brandon in the contacts?
Yes.
Using that telephone?
Yes,
Is that that's a fair conclusion?
that would be.
Okay. And then drawing your attention to line 7.
Okay.
Is there call activity recorded then?
Yes.
And what activity is recorded at line 7 of page 4?
This is an outgoing call, 911 emergency call,
And what time and date are associated with that call?
9:13 of 16 at 6:47 a.m.
And I guess you're associated with the investigation in this matter? Is that approximately the time of the 911 call from the victim at Covert Court?
I haven't done a direct comparison, but I believe it was early in the morning around that time.
Around about that time. Now you said that's what you refer to as a dumb phone. So that phone does not have what, video, picture capability?
Oh, it does have picture and video capabilities, but it doesn't connect to like Wi-Fi and things like that for apps, and it has very limited capability compared to your typical smartphone, Android or iPhone.
Okay, but there was no video or pictures of evidentiary value included within that telephone?
No, I found none of evidentiary value.
Are you able to tell us from your analysis what the phone number is for that phone?
I would have to look through and see if I can find it. Typically, they will be in the front page of the report if it extracts it. If it's taken as a unit identifier, which a lot of times it is, it'll be 1438049927.
But that might not be the phone.
That might not be. Sometimes it'll take it, sometimes it won't.
Okay.
Okay, we got another one. It's also under MSISDN 1419-543-5436, and that's more likely would be the number.
Okay. Now, we have had prior testimony from Captain Lay that phone number, 419-543-5436, is a number that he dialed as being a last call from Elizabeth Griffith to that number, and that would have taken place around August 16th of 2016. If that's the case, and the phone activity, the call activity on the phone as you analyzed it on the day you analyzed it only goes back to September 6th of 2016, can you draw a conclusion as to what happened to call activity prior to 9/6 of 16?
There's a good chance it was deleted.
State's Exhibit 381. Is this a true and accurate copy of the data that you extracted using the Cellbrite system from State's Exhibit 140?
Yes, sir.
And you use this in the normal course of business as an employee of the Ashland Police Department?
Yes.
And does State's Exhibit 140 appear to be in substantially similar condition as it did when it was in your custody and control at the time you analyzed it?
Yes.
Now, there was a second phone belonging to Shawn Grate that you analyzed, is that correct?
Yes.
Now, how did it come that you ended up analyzing this other phone?
Actually, I analyzed that one first of all the phones. I was contacted by Detective Brian Evans. He requested some assistance in the analysis of that phone. He indicated there was questions on date and times of video files that he had seen in the phone or had recovered from the phone, and requested my assistance in going through and reanalyzing it.
We'll show you what we marked as State's Exhibit 151. You've examined that item. Tell us if you've seen it before.
Yes, I have.
What is that item?
This is the the smartphone, but it's a Microsoft Nokia Lumina phone that was provided to me by Detective Brian Evans.
Okay. And did you subject that phone to analysis?
Yes, I did.
And how did you go about analyzing that particular phone?
I ran multiple analysis. I did a file system and a logical extraction of the phone. This phone model with Cellbrite has limited support. That means it doesn't get deleted data like the typical Android or Apple phone. Basically, the software told me all I could get is audio, videos, and images out of the phone. So I didn't have as much to work with as far as other data.
And did you, in fact, find videos and a still photo that are of interest in this case?
Yes.
reference the still photograph, what did that consist of?
Well, there was a couple still, but the one that related to this case consisted of the victim, Lori. It almost looked like a stage picture, laying on her back with something draped over her. It actually almost looked like a picture in a casket. She wasn't moving, looked like she was like asleep or something.
And are there time and date data associated with the still photographs?
Yes, there is.
Now, with this particular piece of evidence, was the time and date accurate as it read on the phone?
No.
Did you go through, I guess, some effort, perhaps is the best way to say it, in order to arrive at the correct date and time?
Yes, I did.
And did you generate a report, I guess, as to your work, reference that phone, as well as, I guess, showing your math on how you arrived at the date and times?
Yes, I did.
Show States Exhibit 382, Defense Counsel. States Exhibit 382, do you recognize that?
Yes, it's a report that I wrote regarding this case.
Okay. And I guess where was the Microsoft phone? What date was it claiming it was, and how did you go about arriving at what you feel is an accurate time?
Basically, I went into the internal settings of the phone to see what the time and date was set on the phone. First thing we have to understand is this phone was not connected to a cell phone carrier directly. Whether the account was closed or it was cut off by the carrier, it didn't have active data going to it or an active Wi-Fi connection that I found on the phone. So I went into the settings part of the phone to try to find out why the date and timestamp was off. And if you're not aware, with phones, they automatically generate labels on videos and images when you take pictures. And generally, they are date and time. That's usually the default to go to unless you change the name on it. So I went to the phone and checked out date and time. And I took a screen capture of the phone within the phone itself, which I later extracted. And the date and time on this, at the current time, now this was the 14th of September 2016, around 3:37 p.m. The date and time on the phone showed January 28th, 2015 at 5:16 p.m. So I knew the phone date and time was off.
Okay.
And I looked at the settings for date and time, and it also showed that the 24-hour clock was off, as well as setting date and time automatically. That button was turned off on the phone too. So even if the phone did connect, it probably wouldn't have updated the date and time.
Okay.
If it did connect to like Wi-Fi or the internet.
And were you able to, I guess, arrive at a conclusion as to when photos and videos were taken?
Yes, I came to a conclusion. I use actually a website called Date and Time Duration to compilate how many days were between January 28, 2015 at 5:16 p.m. and September 14th, 2016 at 3:37 p.m. And I came up with the results of 594 days, 22 hours, and 21 minutes. And that could be a variable based on our time zone that we're in, because this timestamp shows minus 5 UTC, which is basically the universal time coordinate, which is the baseline for time zone. But when I was doing the extraction, and at the time I had here, we were on Eastern Standard Time, which is minus 4. So there could be an hour variance in this.
Okay. So an hour, well, we'll get to that.
Okay.
But how did you arrive at a conclusion as to what time this still photograph was taken?
Yes, I did.
And what time do you believe this still photograph was taken?
It was taken on September 12, 2016 at 5:02 p.m.
Okay. And I guess for the record, how did you arrive at that specific date and time for that particular?
I used that same calculator, programming the original date of in the phone of 128:15 at 5:16 p.m. and then added to 594 days, 22 hours, and 21 minutes, which came up with that time.
So you could see on the phone what time, what date and time the phone thought it was as you were holding it right then?
Yes,
And then there was a time and date associated with the picture that was set with the picture at the time the picture was taken.
yes.
And so it's a matter of figuring out where it should be and then
Yes, I do want to...
doing the math in order to arrive at that.
I do want to clarify, I actually used the time that was associated, time and date that was associated on that picture instead of the original time, then I added the 594 days. So I want to make sure we're clear that it came from the picture and not the original time.
Okay. And so you came out with the 12th of September, I think, 2016
Yes,
at 5:02 p.m.
that's correct.
Now, you said we'd have to adjust potentially for the time savings,
Right,
and so that would mean that if it's not 5:02, it would be what?
6:02,
Okay, so 9/12, you're confident of that date?
yes,
And 5:02 or 6:02, depending.
correct.
Now, there was also video associated with this phone?
Yes, there was.
Should the defense counsel states exhibit 384 and 385? I'll show you states exhibit 384.
Okay.
You recognize that exhibit?
Yes, I do.
And what is that exhibit?
It's a CD containing videos. It has my signature on it and the date that I viewed each video on this CD to verify.
Okay, so you had an opportunity to review that particular exhibit prior to coming to court today?
Yes, sir.
And does it contain the videos that you extracted relating to a particular individual off of Microsoft phone marked as stage 151?
Yes, sir.
And who is contained in the videos that are contained within that exhibit?
It would be Lori and Stacy.
Well, within the state's exhibit 384,
Oh, I'm sorry, Lori.
Okay.
Yeah,
the overall videos contained on the phone have...
Right.
Correct? Okay, but 384 is as to Lori.
that's correct.
How many videos were contained of Lori on that particular exhibit?
2.
Counsel, want to approach?
All right, Mr. Eisenhower, I think you said that there are 2 videos?
Yes, sir.
There are 2 videos of Stacy, is that correct?
Yes,
Okay, so there are more videos than 2 contained in that exhibit.
yes.
All right. Is that,
That was my mistake.
it's all right. State's exhibit 384, is it a true and fair and accurate depiction of what you found on the cell phone?
Yes,
Thank you. 385, defense counsel? Show you what mark for purposes of identification, states exhibit 385. Do you recognize that?
yes, I do.
And what is contained on that?
This is a disc of videos involving Stacy.
And where were they contained?
They were contained from this cell phone that we had recently discussed, this Windows phone.
And did you have a similar opportunity to review that particular exhibit prior to coming to court today?
Yes,
And is it a accurate depiction of what you found on the cellular telephone you were analyzing?
yes.
And who is depicted on those videos contained within State's Exhibit 385?
Stacy and Shawn Grate.
And were those videos subject to the similar time problem?
Yes,
And did you apply the same methods that you've already testified to in determining when these videos were taken?
yes, I did.
And when were the 2 videos of Stacy taken?
They were taken Friday, September 9th, 2016 at 2:04 a.m., or it could be 3:04 a.m., and Friday, September 9th, 2016 at 2:10 a.m. and or 3:10 a.m.
So at 2:10 or 3:10 a.m.?
Correct.
September 9th?
Yes,
Of what year?
2016.
State's Exhibit 382, is it a fair and accurate copy of your report?
Yes,
And it's a report that was generated by you, referenced the phone that is State's Exhibit 151.
yes,
And it is true and accurate and used by you in the course of your duties for the Ashland Police Department?
yes,
And State's Exhibit 151, is it in substantially similar condition as to the day you had it in your custody and control?
I'm sorry, which
The
exhibit?
phone.
This is 38, you mean? Oh, 150, yes, it is. Look at the evidence
Looks
number.
the same?
Yep,
All right. And it is, your handling of what is marked as State's Exhibit 151 is documented within State's Exhibit 120, is that correct?
yes, it is.
Your Honor, at this time, we'd ask to publish video.
I want to identify it more specifically for the record as to what video you want to publish.
Well, I guess we have to bring them up because there's two on this.
Okay.
I guess the first video contained on the disc.
Okay. Any objection, Mr. Whitney? Okay. Do you have it queued up? Because I'm seeing two files, so yeah, if you just want to pause it, we will publish it. Oop. Proceed.
Mr. Eisenhower, at least looking at that particular video, the initial portion of it, do you recognize that video?
Yes,
And is that video from the Microsoft phone that you analyzed?
yes, it is.
Right now. Just tell me I can leave.
When you get,
You did.
huh?
You did.
I haven't yet. I was up when I did golf.
No, but you mean,
Your Honor, I'm going to reconnect so we can see the audio.
Okay. I'll black out the TV until then.
Right now. Doing good. Won't be around. Right, there it is.
you told me I could leave. You did.
Huh?
You did.
I haven't yet. I was up when I did golf.
No, but you made me have sex with you.
No.
I have to look my dog's out.
I'm sure the folks look at me right now. Just to get your time.
You're not being stupid. I didn't say that.
Clever when you did. Yeah.
And there's a second video, is that correct?
Yes, sir.
And what does the second video depict?
Stacy, being raped by Shawn
How is she being raped by Shawn?
orally.
It appears, as we look at that video that was just published, that there is, would be her right eye appears to be dark red. Did you see that?
Yes, it appears to be petechiae, which is very common with strangulation, choking. We've been taught that in the police academy through various investigative courses, especially relating to domestic violence. It is a sign of a choking or a strangulation.
And is there any doubt in your mind the male subject depicted in that video is Shawn Grate?
No doubt.
That's a fair and accurate depiction of the video as you extracted it from the cellular telephone that was found in the house on Covert Court?
Minus the choppiness, yes.
And ordinarily it's not so choppy, correct?
Correct.
Just to briefly revisit State's Exhibit 384, the videos in State's Exhibit 384, you can see the defendant completely, correctly?
That's correct.
Okay, and they're contained within the same cellular telephone as you found the exhibits that are contained within 385?
Yes.
And the voice is the same?
Yes.
And so the videos within State's Exhibit 384 were helpful to you in part in identifying the individual as is 385?
Yes.
Thank you. Nothing further.
Cross-examine.
No questions as witness. Judge, thank you.
Thank you. Your excuse, Mr. Eisenhower. Next witness.
Your Honor, subject to the admission of the exhibits, any further outcome of any further motions relating thereto, testimony, or any potential rebuttal witnesses that may be necessary, the State of Ohio will rest.
Okay, thank you. It's 12:09 on the courtroom clock. Ladies and gentlemen, we have some issues to address outside the hearing of the jury. So at this time, we're going to take lunch recess, and counsel and I will address those issues while you're on a lunch break. Gentlemen, about how long do you think that'll take? I want to give you guys a break too
For the admission of exhibits,
to address exhibits, any motions and so on.
based on our last conversation, perhaps a while.
Okay. I think a 2-hour recess for the jury would get it done.
They should do it.
Okay. Then, ladies and gentlemen, it's now 12:10. I'm going to ask that you be back in the jury room at 2:05, so we can maybe get started by 2:10. Again, although the state's resting subject to the admission of exhibits, motions, and so on, you still don't have everything, including the court's instructions, so you're not to form any opinions, draw any conclusions, don't talk to anybody, don't let anybody discuss it with you, don't discuss it among yourselves, don't look at any media reports, or anything of that nature. Continue to comply with the court's admonitions, and with that, the jury's excused until 2:05 p.m. Okay, it's 12:11 p.m. on the courtroom clock. All jurors have left the courtroom, as well as all alternates. Defendant remains, as well as counsel for the defendant, counsel for the state of Ohio. So you want to start with the exhibits or motion? Let's start with the exhibits before we entertain motions.
Is there a motion, Judge?
Well, you haven't technically rested your case until I've ruled on the admission of exhibits, and if there's any Rule 29, that should be made after the exhibits are admitted. So, defense counsel, are there any specific exhibits offhand that you know you're objecting to their admissibility? Okay. Well, let me go to the ones that I may have some question about because they may or may not have been identified. Was Exhibit 40 identified for the record?
No, it was never identified, and we don't see.
Okay, so
Actually, Judge, we've got a couple like that, if you want to run through that.
that's what I'm running through. That's what I'm running through.
State's Exhibit 40,
Mm-hmm.
180,
Yep.
269, 272.
Yep, I got 269, 272, yep.
Yes, sir. 383 and 387 are not in play.
Okay, now 383 was identified for the, it was identified, well, he testified to the exhibit, but yeah, you're right, okay. So those exhibits will not be admitted. They weren't, they aren't being proffered at this time by the state. I guess the only exhibit that the court has some question about, since defendants saying they're not objecting to any of the exhibits, is Exhibit 384, and it's basically the same discussion, gentlemen, that we had up here at the bench. We can't unring the bell as to what evidence concerning the offenses committed against Lori Svilik the jury has seen, and defense counsel has stated for the record that they'll waive any objection or any, I guess, appeal right in that regard. I won't even go say that far as to, they're just basically recognizing it is what it is and not rendering any objection on that. But again, my concern is with 384, the jury's entitled to see the evidence that's admitted, all the exhibits admitted into evidence. And that may be perhaps our disagreement. I don't have a problem making 384 a part of the record in this case for appellate purposes, but I'm certainly not going to send it back to the jury. And for that reason, I don't believe it's admissible as to the remaining charges, and I'm not going to admit it for that purpose. The state may proffer it for other purposes and will make it part of the record. But I'm not going to say it's relevant under Rule 403B at this point. I don't think it is.
Well, I don't disagree with the
403.
court that it shouldn't go back to the jury. I don't think it's for them to see. I will say that it is relevant in that we've had testimony from Mr. Eisenhower that the defendant is visible within the videos contained in there, and it helps to form the basis of this conclusion that Patty Sue is in fact depicted in 385. I don't think it's necessarily so relevant that it should go back to the jury. I think, however, and I have a disagreement with the court on this point. I think it can be admitted, but despite its admission into evidence, and that's how it ends up in the record, that it doesn't have to go back to the jury. I'm fairly confident the defense would stipulate that it not go back to the jury. Now, if it's not admitted to being part of the record...
Well, we may just be talking semantics here. What you're saying is conditionally admitted for the
Yeah,
record.
it's been properly authenticated, and it has some relevance, but the prejudicial qualities of it...
Yeah.
He's pled to those counts, and I don't think that jury should see it. I agree, but as long as it's in the record for appellate purposes and, to buttress the testimony of the witness, I think it's admissible for that purpose.
Judge, I should also say that that's what our understanding was when we approached this at the beginning of the morning. So I don't...
Well, state that for the record, what your understanding was, so it's clear for the record.
Our understanding was that the
Can we
exhibit
turn some
would
lights
not go
on
back
here?
into jury, but it would be made as part of the record.
Well, just including it with the exhibits and having it identified and authenticated in the record makes it part of the record of this case, because even exhibits that aren't admitted remain part of the record. And that's how I viewed this exhibit at this point in the proceeding. Had it been offered prior to the pleas, it's one of those bells that you can't unring. But we'll call it what it is. If you guys want to call it conditional admittance, that's fine. It's not going back to the jury, and that's the court's ruling.
No objection to that.
And that's how it'll treat it, but it'll be part of the record. It'll be shown as limited or admitted for appellate purposes only. Okay? So with that, basically, let me run through all of the exhibits then, with the exceptions of the one we're excluding, so we've got a record of what's being admitted. We have exhibits, and I've got 30 per page because I transferred all the state's exhibits over to my format so I could track whether it's identified, authenticated, and or admitted. I've got exhibits 1 through 30.
No objection.
You're right, admissible without objection. Those will all be admitted without objection. Then I have 31 through 39, which I understand there's no objection to.
No.
And those would be admitted without objection. We skip 40. That's already been addressed. It's not being offered. Then 41 through 60, my understanding is there's no defense objection.
That's correct.
So 41 through 60 will be admitted. Next, I have 61 through 90. They're all being offered, and then my understanding is there's no defense objection to 61 through 90.
No objection.
So 61 through 90 are all admitted without objection. Next, I have 91 through 120. And my 91 through 120 are admitted without objection. Next, I have 121 through 150.
No objection.
121 through 150 are admitted without objection. Next is 151 through 179, because 180 is not being offered. So 151 through 179, Mr. Whitney.
No objection.
151 through 179 are admitted without objection. 181 through 210.
Your Honor, 181 through 197 all relate to Lori and Lori's just...
Yeah, I understand that, but these have actually been published to the jury, unlike the video. And like I said, you can't unring a bell, and if the video that the jury hasn't seen is entitled to admission, then something they've seen should be entitled to admission under that same analysis. Right?
It's the same as the campground, essentially, so I don't think they're already admitted to work on that.
Well, they've already been published. You can't unring that bell. If you want me to admit them for limited purposes, they can be admitted for limited purposes, the same as the stuff they haven't seen. But again, the way I read the rules of evidence and the admissibility of the exhibits, if it's relevant evidence, and then it should be subject to admission. If it's not relevant, it shouldn't be subject to admission, and the jury's entitled to anything admitted. This is a unique situation where after the evidence is presented, the plea is entered. But again, I think I've stated my position. I understand the state's position, but by that same argument on the state's position, I think they got to come in as part of the record in this case. We can make 181 through 191 subject to or admitted for appellate purposes only at this point.
We're okay with that, Jim.
Okay. So 181 through 91 will not go back to the jury during deliberations, correct?
197.
I'm sorry, 197. I didn't go down far enough. So 181 through 197 are admitted for purposes limited to appeal and don't go back to the jury. Okay, then we pick up with 198 through 210. Any objection? 198 through 210 are admitted without objection. Next I have 211 through 240. Some of these have been pled to, the stuff with the trailers and the...
Yeah, beginning at 216.
Would the parties agree that they should only be admitted for appellate purposes? Either side can answer first. You don't have to wait on the other one.
I don't have a problem with that, Judge.
It goes down to 216 to 243.
Okay, so we'll include 241 through 243 on that. Mr. Whitney, you okay with that, through 243?
And then Your Honor, 244 to 258 are all the safe exam things for Lori, so 244 to 258 on the same basis.
Okay. Any objection to them being admitted, limited to appellate purposes? Okay, 259 through 268.
$268, you said?
268, yes. 259 to 268. Exhibits 259 through 268 are admitted without objection. I'm just going to go back a page just to make sure I covered it in the record that 211, 212, 213, 214, and 215 were admitted without objection. I don't know if I specifically said that or not. We skip 299 and have 270, the Yahtzee box. Is that one that would have limited applicability?
No, Your Honor, that's from Elizabeth Griffiths.
Oh, okay, you're right, yeah. Okay, any objection to 270? $270 is the Yahtzee box. Any objection? Okay, 270 is admitted. We then have 271 through 300 with the exception of 272 that wasn't identified for the record.
What's the last one, Your Honor?
300, minor in blocks of 30.
Okay. Just noting that 283B, there's 283 and 283B, and it was included.
That was that supplemental portion of the transcript. It wasn't included on the audio. 283B is the additional audio clip. And that would be included in this range. Any objection to any of those, Mr. Whitney? Okay, 271 through 300, inclusive of 283B, but exclusive of 272, are admitted without objection.
The, anyone sending transcript copies back as well?
They're part of the exhibits. They've been identified for the record. The jury's already read through them, so that's one of those unring a bell kind of things.
Copies, I assume that we were, that's why.
That was my expectation when they were offered to the jury initially. So now we're at 301 through 330. Any objection to any of those exhibits?
No.
301 through 330 are admitted without objection. 331 to 360, any objection?
Only with respect to 347, Your Honor, that's a photo of Lori's apartment door, so on a limited basis is the 347.
Okay, subject to that, any objection to the, okay, 331 through 346 are admitted without objection, 348 through 360 are admitted without objection, and 347 is admitted for the limited purpose of appeal. That will not go back to the jury. Next I have 351 through 389. I think I've already entered a ruling on 384 at this point, or maybe I haven't, but we've talked about it. And then 387 and 383 on that page are not being offered by the state. So it's 361 through 382, then 384, 385, 386, 388, and 389. With the exception of 384, any objection to any of those exhibits? No. And everybody agrees that 384 is limited for appellate purposes only, correct?
Correct.
Thank you, defendant. Counsel. Okay, then that takes care of all the exhibits. And state rests?
Okay.
Sure.
Your Honor, item 386, the bag of cut-off shorts from Charles Hill.
Right.
That could be conditionally admitted.
Conditionally admitted for appeal purposes only? Any objection, Mr. Whitney? Okay. So we'll modify the ruling on 386, limited purpose. Okay.
Yes, Your Honor, at this point, the state would rest subject to those other conditions of this.
Okay, thank you. Any motions?
No.
Okay. And does the defendant intend to offer any evidence?
No, sir.
Defendant's rested. Sorry?
I'm sorry, Your Honor. In the absence of a Rule 29 motion, the state would submit for the record that in a light most favorable to the state, there has been evidence deduced sufficient to touch upon every element of the remaining offenses and charges within the what's left of the indictment at this point. And so we would ask the court to at least do
Affirm.
a cursory Rule 29 review and arrive. We would propose a similar conclusion.
Okay. Well, yeah, I've come to that conclusion. There's sufficient evidence that's been offered with regard to counts 1, 2, and the specifications with regard to those counts. Count 3, count 7, count 8, and the specifications to those 2 charges, count 9, and the specifications to count 9, count 10 and the specifications to count 10, as well as count 12, the aggravated robbery charge. To sustain a prima facie case, and the court would find that a Rule 29 motion would not be granted at this point, that the state has met its burden under Rule 22 to defeat a Rule 29 motion.
Thank you.
You're welcome. So defense is resting?
Yes, sir. Yes.
Okay. Well, with that, then the evidentiary portion of this trial is concluded. Gentlemen, when the jury gets back at around 2 o'clock, it would be my intention to, since we don't have the hotel space this weekend for sequestration, and since we need to talk about jury instructions anyway, which we've already kind of decided we were going to do Friday, I'm going to discharge the jury for the weekend and ask them to come back Monday morning. I am going to give them some information about sequestration so that when they come in Monday, they can bring their luggage with them and be prepared for that potential. And then we'll conclude for the day with the jury, get them out of here. If you guys want to talk about jury instructions yet today, we can. If not, we can wait till Friday.
I need to go back and I confuse myself.
Yeah, I was going to say, just sort through everything and see where we're at.
What time do you want to get together Friday?
I was just going to open my calendar to take a look at that. I mean, we normally would be starting at 9 o'clock. I plugged in a 1 o'clock change of plea thinking I would have at least a long lunch hour that day, and then, but that's it. I've just got a 1 to 1:30 change of plea. If you guys want to do it in the morning, we can do it, say at 9:30, 10. We could wait till the afternoon. It's whatever you guys want to do.
10 o'clock's fine, is it?
I know you guys have staff meetings on Fridays, so do we, so we can get that out of the
I'm
way.
kind of curious to see what's going on.
So 10 o'clock, then we'll come back at 10 o'clock, counsel only with the defendant, no jury, and we'll discuss jury instructions for the trial phase and conclude that. That's my understanding after the jury's charged on Monday of next week, and we get them going, that at 2 o'clock we're going to be doing the video evidentiary or admissibility determination hearing, correct? That involves both 702 and 403 issues, correct? Scientific reliability, and then whether or not it's relevant, even if it is scientifically reliable.
I know oftentimes in a dog hearing, they've already performed the test.
Well,
Now, in this situation, it would be Daugherty, just with the exception of the test on the defendant being performed.
right, it's basically, what's
Background.
well, just background on the process and what is it attempting to produce, and if it produces what it says it's going to be. Here's my view of going into that hearing. Is it going to produce what it says it's going to produce, or is it just a function of the data settings that are plugged into the MRI to produce a known result based on the calibration of the MRI? Is it really testing something, or is it not? Is it just producing predetermined data? I don't know. because they got to plug their own specific settings into the MRI machine. So that's one of my questions. Number two is once you've got the MRI result and the analysis that they perform, what's that really mean? And does that mean anything within a reasonable degree of scientific reliability or certainty?
That's fine, Judge. I'm just saying the only branch that wouldn't apply is the part where there's a test that exists and why this test, would be admissible in the dog. There's just
Well,
stuff that we have got to reach.
No, I don't think that's necessary. Let's put it in the framework of something that everybody's pretty familiar with, which is, OVI testing or speed testing and the equipment utilized for that that's generally been recognized. And you can't challenge the reliability of, say, an Intoxilizer 6000 test under Daubert, but you can still challenge the validity of the test itself because their test has been performed. But what leads up to that point, or say a laser reading or a radar reading from a speed measuring device, is what's the reliability of that equipment to capture the accurate speed before we ever worry about a specific test.
Right, we're saying the same thing.
Yeah. Okay. Very good. Anything else then before 2 o'clock that we need to address, gentlemen?
You want the defendant here at 2 o'clock?
I do.
Yeah,
Okay.
Jury's going to be in the room, defendant should be in the room.
agreed.
Okay. Well, and gentlemen, if there's nothing further, it's 12:39 and we're in recess until about 2 o'clock or a little thereafter. Thank you.